Be cool, be kind, be classy. A cupcake so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions of lemonade. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello, happy Tuesday. Hey, cupcakes, what's up? Today is Tuesday, November 25th, 2025, 11/25/25. We're going to Salem today to watch the Kelsey Fitzsimmons hearing that's scheduled for noon. If you thought you were going crazy, you might have been, because I mistakenly set this stream for 11:45 p.m. just a little while ago. And then one of the amazing viewers pointed out to me that Creating Through Chaos that said, I think she messed up on the time. And that's what brought my attention to the fact that I had set it for PM instead of AM, although I would have gone live at AM anyway. And then everyone would have been screwed up. But I did call the court this morning and they said, yeah, no, we're not going to do any Zoom or anything. You have to come in person. And it looks like NBC 10 Boston is going to be streaming it. So we're going to get to watch, hopefully, a good feed. Assuming they have a camera in the courtroom. Kelsey will be there today, as we discussed yesterday. If you weren't with us yesterday, we went over the entire Commonwealth brief that they have submitted to the full panel at the Supreme Judicial Court in Massachusetts. And we're going back to Salem today. This is supposed to be a trial scheduling conference. We'll see how it works out. I also have a motion that Tim Bradl made, a defendant, Kelsey Fitzsimmons' motion for specific discovery, where they are requesting a lot of specific information, 18 items of specific information, which we will look at after this is over. What's on your mind, people? What's on your mind? Did you watch Billy Bush this morning with Turtleboy? Turtleboy was on Billy Bush this morning at 10 a.m. It was interesting. Billy Bush suggested that he do a show with Karen Reed and Turtleboy at the Beacon Theater, but that's in New York. So I don't know what that was about. But okay. It's not, I don't think it's ever going to happen, but we'll see. Hang on. I love Billy Bush. But the thing is that he doesn't promote his shows properly. Billy, if you're listening, dude, you didn't even have in your title of your stream today that Turtleboy was going to be on your show. So how would anyone know unless he told them? So I don't know. You got to promote it properly so that people tune in. And I know I said I would be the mediator. And even Aiden even said on the show, Melanie Little has offered to, try and help us work things out. Not even like on the air. I would do, privately. And then he said that he wanted to do it. So thank you. You guys, these names are really screwing me up. I wish you could change them back to your old names so that I knew who you were, because I know who you are from your profile picture. And I think your name is Amanda, but And I think you live in Arkansas, but I can't tell because it changed your name back to Felishel or something such as like that. Yeah, it's just not time yet. It says little cupcake. It's not time yet. I don't know if you're referring to that or you're referring to the Kelsey hearing, but maybe. Yeah, and Cherie. Hi, Cherie, all the way from down under. Says I only saw it because Aiden mentioned it on his bus stop stream. Putting Turtleboy's name could lose listeners. Well, Mary, I beg to differ because it was the largest crowd I think I've ever seen on his show for a live stream. There was over 1,000 people in there. And if you watch him in the morning, you know that he usually has a couple hundred. So YouTube changed names permanently, Mitchell. Well, I think there's a way for you guys to change them back. So do not fear. You guys are smart. I'm sure you could figure it out. And if you can't figure it out, there's probably somebody in the chat who can figure it out. And they will tell you how to do it. I don't know how to do it because my name is the same no matter what. So it doesn't matter. Up here, Poe Hunter is going to tell you how to do it. PSA, how to change your chat name. 1, click on your profile picture in the top right of your screen. 2, click on view channel. 3, click on customize channel. 4, find handle. 5, change to what you want. I'll leave that up for a minute or two so that you guys can do that. All right, let's just put the stream up so people don't flip out and they know that it's coming because it's coming as soon as they turn up their cameras. And hopefully maybe we'll have good sound today and all the things that we like. I don't know what's going on here. There's a still photo of Kelsey while we wait. And we'll put it like that. Somebody's saying your name has to match your handle. I don't know. They don't ask me. Listen, if YouTube asked me, there's a lot of things that I would ask YouTube to change as a streamer. For one thing, the block list, there's no way to sort it alphabetically. There's no way to see who was blocked when and who did it. There's no way to see who the last person blocked. It's just, there's a lot of things on YouTube that should be changed, and they're changing all kinds of things that don't need to be changed. And so I don't know. I don't know. Cassandra, I don't even know who Kresha is. And I've seen you put this in the chat like 4 times. I'm going to delete it again because I don't know who that is. And also, I don't give out legal advice on my channel to anyone, to viewers, to people. I'm retired. I don't give out legal advice. That's not what my channel is for. And so please don't email me any of your court documents. Don't email me a request for me to represent you. Don't email me and ask me to just give you legal advice on your will or your family disputes or anything else, because it's just not what I do. It's not what I do. I'm retired. This is legal commentary, and this is opinion-based, and this is what I'm doing is what I'm doing. You have to change your tag name, says Tiff. Tiff says you have to change your tag name. No, Kelsey cannot get released today because that issue is in front of the appellate court, and this issue is in Superior Court in Essex, which is in Salem. And this is supposed to be a trial scheduling conference, and it's in front of the same judge that Kelsey was in front of before, the male judge. It's not Judge McCarthy Neyman anymore, but it's the male judge who was very angry with Tim Bradl last time because there were so many people interested in the case that their phone system couldn't handle it, because I don't think they do Zoom there. I think they only do this like party line type thing. It's like a conference call that you have to dial into. And the judge got very mad about it. And so this is supposed to be a trial scheduling conference. They're supposed to pick a trial date, but I am assuming they're also going to talk about discovery that's outstanding. Unless there's a motion that was filed today that I'm not aware of asking for reconsideration of the bail, which is something that we went over last night in the brief that the Commonwealth filed, in which they also said that they didn't believe that Kelsey was disabled. And they dedicated literally maybe 2 paragraphs to the Americans with Disabilities Act, which I think is the strongest argument here. They said, well, I mean, she could always come back when she's feeling better and ask the judge to reconsider when she can breathe into the SCRAM device. And so, it's already been like 10 weeks since her first motion. So it's hard to understand. It's hard to believe that she's not better by now, because of that excellent medical care that they get in the prison medical ward, right? I mean, come on. On top, it's here. Thank you for your super sticker. Casey Cat 1 says, can you give a quick breakdown of this case? There's nothing quick about it, but I can try. Kelsey Fitzsimmons is a North Andover police officer who was engaged to a North Andover firefighter named Justin Aylaian. They had a baby together back in February. They were scheduled to be married in October, this past October 2025. And on June 28th of 2025, Kelsey and Justin went to Maine with, I guess, a bunch of friends and family for a bachelorette party. I'm not sure if it was a bachelor party and a bachelorette party because Justin was there. And something happened. They got in a fight. And so that was on June 28th. On June 30th, which I guess would have been the Monday, Justin went into court by himself, filled out a piece of paper. It was handwritten and said, Kelsey got, something like this. I'm summarizing. Kelsey got drunk at her bachelor party on Saturday night, and she was aggressive towards me and towards other people. And I have a fear that she might harm herself or our baby. And the district court judge, I believe it was, I'm not sure, Lawrence, I'm not sure. Was it Lawrence? District court judge gave Justin a restraining order against Kelsey and also gave Justin an order that he could take the baby away. And so on June 30th, while Kelsey was sitting home breastfeeding her baby, who was 4.5 months old at the time, maybe 5 months old, 4.5 months old, while Kelsey was breastfeeding her baby, there was a knock on the door, knock, knock, knock. And 3 of her fellow North Andover police officer buddies were there, and they're like, hey, Kelsey, we got this order to take your baby away, and we got a restraining order from Justin. And so Justin's going to come and pick up the baby and, peace out. And while she went to gather some clothes, she says that her story is that she saw her life flash before her eyes, her career, her child, her wedding. While she was gathering some clothes upstairs, one officer followed her up there. He says she ducked behind the door in the bedroom, pulled out her weapon and pointed it at him. She says, number 1, there's no door in the bedroom at all. And number 2, I only pointed the gun at myself. I wanted to hurt myself. This officer Noonan pulls out his gun and shoots Kelsey in the chest. She's airlifted to Massachusetts General, where she stays for 53 days. She undergoes at least 5 surgeries where she has a collapsed lung, lacerated liver. She still has bullet fragments in her chest. And then the Essex County DA decides to charge Kelsey with attempted murder of Noonan, and no body cameras, of course. We're in court. There's nobody there yet, but the camera's up. And so she's airlifted. They decide to charge her. She is then arraigned in her hospital bed. The case goes to the grand jury. The grand jury does not indict her on the attempted murder charge. They indict her on assault with a weapon, which carries a maximum of 5 years. And under the sentencing guidelines, because of Kelsey's lack of a record and her standing in the community and her job, she would be entitled to probation. However, she's in jail. If the audio sync is off, just refresh your own browser, and hopefully that will fix your problem. Smooth Jazzy. They make a petition. Bradl makes a petition saying you should be let out on bail. Anybody else should be let out on bail, and so therefore you should let her out on bail. She's not a danger to the community. The court has many, many hearings, couple of hearings, and decides finally that Kelsey can be released under house arrest. She has to stay with her her mother and her stepdad with an ankle monitor, and she must breathe into this alcohol monitoring device a couple times a day. That same day that the judge finally decides to release Kelsey, Tim Bradl asks the judge if the ankle monitor can be installed the next day because she has surgery scheduled for the next day after she got out. Judge says no. And so she cancels her surgery. And then 48 hours later, Tim Bradl makes an emergency motion saying, listen, it's very painful for Kelsey to breathe into this device to test her for alcohol. She can do it, but it's very painful. So can we find a less restrictive measure, a different way to test her for alcohol monitoring, aside from breathing into this tube, which is very difficult because she's got broken ribs and she's got a lacerated liver and she had a collapsed lung and we're requiring the insertion of a chest tube. And the judge says, oh, well, it's torturous. I don't want to torture her, so I'm just going to throw her back in jail. So she's back in jail. We are all the way up now at the highest appellate court in the land of Massachusetts, this full panel SJC. They have, I guess the wedding was canceled. Yeah. And here we are still. Kelsey is still in jail. She's being held in Chicopee because she's a police officer. I guess they thought that would be more secure for her, although she has been harassed in jail. She has not seen her breastfeeding infant since June 30th. And today's hearing is to determine a trial date because the appellate court is going to decide whether or not Kelsey can be released on bail. This whole thing is horrific. It's outrageous. Alcohol was not even involved in this alleged crime in which Kelsey says she only pointed her weapon at herself. And so we're horrified by this. Tim Bradl is her attorney. He also represents Turtleboy. Martha Coakley, who's the former attorney general for the state of Massachusetts, has also stepped in to help as defense counsel. But the judge who heard this case had really zero empathy, zero willingness to cooperate. And her name was Judge Kathleen McCarthy Neyman, and she threw Kelsey back in jail without even a thought. We listened to the hearing on audio because that's all that was available, and her tone and her demeanor was outrageous. It's unlike anything I have ever seen as an attorney with over 30 years experience practicing in New York State and federal courts. Outrageous. Thank you. Thank you, Casey Cat, for coming to my very brief rundown, which I think I got everything in there. People in the chat could add some more stuff. Thanks for your super chat. This is her courtroom today. Yes, it is. We're waiting. Thank you. Hit me with your best shot for your super sticker. And Norman Corey is here. Thanks for your 10. Says Melanie, they don't want Kelsey to be able to talk to the media like Karen did. What do you think? Shame on them. The cruelty is staggering. That's an interesting point. That's an interesting point, Norman. I never really thought of it that way. But Tim Bradl has not been silenced. He will keep talking. And he's going to keep talking. And he's outraged by it. But you know what? You might have a point there. Thanks, Norman. Thanks for your 10. Thank you. So this is set for noon, but as you can see, there's really nobody in the courtroom as of yet. Today's judge is Judge Thomas. Tell me if it's Dreckler or Dreschler, Drecchsler. He's the same judge who last time, all the way back on October 7th, which seems like a year ago, got real mad at Tim Bradl for, number one, not showing up in person, and number two, because there was so much public interest in it, that the phone lines were overloaded and there were a lot of supporters in the courtroom for Kelsey. Hold on. Thank you, Steve-O. Steve-O says, they didn't care about her safety. They put her out there so that visits and contact was harder for her and her family. Irene says, wow, look at that seemingly new courtroom. I bet they even have Wi-Fi. We'll see. Are there any boots on the ground in the chat, or is there anyone who's in the courtroom in the chat? The arraignment of Gregory Groom was also this morning. Oh, there's Tim Bradl, Silver Fox, from what I understand, and it's supposed to start at noon. And I called the court, and that was in Bristol, Superior, and they said, yeah, we don't use Zoom here, but you can come in person. He is the boyfriend of Kylie Montero and is accused of taking her life, and she was pregnant. The life of her unborn child as well, I believe he's charged with. And that arraignment was supposed to happen today. But we had no way to watch it because, I don't know, Massachusetts. But it seems like sometimes they allow the cameras in, and some of these counties just don't have Zoom capability, or they just don't want to turn it on.
Calling number 22 on the list, Commonwealth versus Kelsey Fitzsimmons, document number 2577, January 11. Counsel, please identify themselves.
Good afternoon, Your Honor. James Chicopee on behalf of the Commonwealth.
Hello, Your Honor. Tim Bradl on behalf of Kelsey Fitzsimmons.
Good afternoon, Your Honor. Martha Coakley on behalf of Kelsey Fitzsimmons as well. All right, good afternoon.
Judge, can I ask as a preliminary matter if Ms. Kelsey might be permitted to join us? Ms. Fitzsimmons might be permitted to join us at the council table.
No, I only do that for a change of plea, a trial, or an evidentiary motion to suppress, and I don't.
Can you guys hear it okay? There's Kelsey standing behind the glass, and Bradl said, can she join us at the table? And the judge said, no, I only allow that for change of plea. I'm sorry, what? We may have to replay this because it's hard to hear. The captions are on. I boosted it as hard as I could, as high as I could.
See why I should treat her differently than anybody else. So the answer is she's here at your request, but no, I'm not going to let her sit in council. Otherwise, I have to allow that for everyone, and it presents a security concern. So if I do it for one person, I have to be consistent.
All right, if I need some time with her, Judge, I'm soon after that for it.
Which, of course you can. You can go talk to her as much as you'd like. Okay, so this is on for trial assignment today. I indicated in the phone conference that we had back in October that we could try it anytime. So let's do that.
So, Judge, a couple of things on that. We think that's a little premature for several reasons. I have 3 outstanding discovery motions that we ought to talk about today, if that's all right with the court, that sort of are, stepping stones to getting ready for trial.
Have you filed?
Yes.
Okay. Let me see.
So 2 of them were filed on August 26th.
Okay.
And the other one is, and I'm certainly happy to give counsel some leeway. This was filed, I believe, last week, November 21st. And so if counsel needs more time on that one, I certainly don't have a problem with it. And I will grant you, I'll acknowledge, Judge, that Kamal's given me a pretty fair amount of information that we're going through. But as you can imagine, and as I know you know, that sort of begs further questions about more discovery.
Well, I have one motion here for specific discovery.
Well, Judge, we filed 2 motions on August 26th,
Okay.
and I have copies of them here.
And what are they entitled?
There's a motion for court order disclosure and release of arraignment, and there's a motion for the Commonwealth may well be in compliance with some of that or most of it, and so those are really the first ones, Judge.
What is that?
Sorry.
Okay. The camera is allowed in the courtroom, but it has to be silent. No exceptions. Thank you.
The first one is the motion for exculpatory discovery, and that is essentially a Graham McFarland request regarding certifications by the officers, whether there's any prior incidents. And that is a predicate to a Rule 17 for that, so that we have a good faith basis, if any, to file a Rule 17 for any further information. And my brother's telling me that that's fully complied with.
Okay,
And I'll defer to him on that.
okay.
No, I think I complied with my obligations under the.
Okay.
As far as that first motion, there are things in there that in the first motion that I do not agree to.
Okay,
And we can go through them if we'd like, but other than that, we have a list of questions that we ask every potential witness, police officer.
Right.
Database, but that has all been complied with.
okay.
But if he wants to talk about the first motion, I'm happy to do that. No action has been taken.
Which, when you say first, I've got three motions here.
Motion for exculpatory evidence.
Okay,
Exculpatory discovery.
So that's essentially what we're talking about, Judge, the Graham McFarland request. And, you know, it's also obviously a Brady request as well. So I think it's more than just, you know, Graham McFarland. It's any exculpatory evidence that's known to the Commonwealth, whether it's the Commonwealth prosecution team or the police team as well.
so, Mr. Gubitosi, the motion for exculpatory discovery,
Yes.
what is it that you object to?
I object to number 1C,
Okay,
number 1D, number 1H, I,
okay, hold on.
and J.
C, D, H, I, and J.
And then that's on number 1.
Right,
Number 2, he wants me to certify in writing that I have made inquiry of every prosecutor in my office for all items and information favorable to the defense. I don't think I have an obligation to do that.
right.
We did that on every single case. We do have a database. We do have a process. We do ask each individual officer these questions, but we do that on every single case
Right.
in the county. That's thousands of cases to some 80 some odd prosecutors
Right.
every day.
Well, and it doesn't include all of the prosecutors that have passed through the office, that have come and gone over the course of the years. Are you suggesting, Mr. Bradl, that the Commonwealth needs to contact each and every prosecutor that has ever worked in the district attorney's office throughout the officer's tenure?
No, Judge. I'm not.
Well, that's what the motion asks for.
No, it doesn't, Judge. It asks them to have, maybe they could use a computer database. Maybe they can log, just like, you know, lawyers have record-keeping responsibilities. Lawyers have conflict checks. There's all sorts of things that are precedent for this kind of a thing. When a prosecutor has a case where some questionable police activity has arisen, prosecutors can easily document that in this case, Officer Jones was found to be not credible by Judge Smith.
Well, I understand that, but
Locked.
let me start with I. Whether the officer has signed a search warrant, I probably see 2 Frank's hearing requests a month in this session, 2 or 3. Most of them are not allowed. Occasionally they are. And just because there is a Frank's hearing does not mean that there was a finding that anyone gave any false information.
Sure.
So how would anyone determine that?
Well, Judge, again, these are record-keeping requests. And
But who keeps a database of that
so
for the last 10 years?
when you're a prosecutor in a district attorney's office and you finish a case, you are required to follow office procedures to close out the file.
Right.
And there's no reason why a prosecutor's office ought to exercise willful blindness about these issues.
So you feel that it's up to you to decide how the district attorney's office conducts its business?
It's up to me to decide.
Did you work in the Essex County DA's office?
Judge, I did not work in the
Okay,
Essex County
so
DA's office, but I do
From
know a
when,
little bit about it.
what are you speaking about when you say that this is how a DA's office ought to be conducting itself? What's the basis for that?
Judge, okay. I don't think it's a obscure proposition, Your Honor, that when a public agency such as the district attorney's office has to close out a case, that they have to comply with record-keeping obligations under the law,
But
under FOIA, under record-keeping for all sorts of things about what happened with the case.
Well, I understand, but Mr. Gubitosi has represented that he's gone back and searched. They have a process. I'm sure that he'll advise you as to what the process is. And if you want to critique the process, that's up to you. But in terms of them producing evidence that is in their possession, custody, and control, he can only produce what he can search for. And the fact that you disagree, maybe you do, with the way in which they keep records or the type of records that they keep is not an issue that I'm going to decide. I don't know of any case law that says that I'm the one, or you for that matter, to decide how the district attorney's office keeps records. And in fact, I'm not going to order anybody to retroactively go back and search records from, I don't know how long the officers who are witnesses in this case have been police officers in this county, but do you know, Mr. Gubitosi, off the top of your head?
And then one of them is 20-something years?
Yeah, so I'm not sure that I can ask them to search records they don't have, but there is whether the officer has ever attended or presented at a law enforcement training by the private vendor.
Just before we jump off of that one,
Yeah,
all the Commonwealth has to do is ask the officers. There's 4 officers that were at the scene. They can ask 4 officers, were you ever involved in a Franks hearing? There are ways to do this. We don't have to act like this is some obscure thing, Your Honor. This is exculpatory evidence. We have every right to all of these things under Graham McFarland and under Brady.
what case says you have a right to find out whether any police officer on any case has ever refused to answer questions?
A police officer in our case, Your Honor.
No, in this case, what is the precedent? You've got to cite, where is the case or statute that says that a police department has to disclose to you or to anyone else when an officer declines to answer questions? There are a lot of reasons for that, I can assure you. And I'm not aware of any records that are kept of that. And I can assure you that it would never be admissible under any circumstances. So I'm having a hard time with the concept that the DA's office or the police department has to supply you with the fact that an officer 15 years ago declined to answer questions after a shooting at the scene, but 2 days later answered the questions, for example. Happens quite frequently. So I am reluctant to say, I doubt there's any police agency that keeps records like that. I don't know of any, but certainly the district attorney's office doesn't keep records like that.
Your Honor, I certainly am not telling you anything you don't know, but just put it out there on the record. When an officer takes the fifth, so to speak, it's been found that a truthful answer would incriminate them. So it's incriminating information.
Who's made that finding? That's an interesting concept because I probably represented thousands of officers at interviews, and I yet to have or even hear of someone making a determination that that person.
There it is. You wanted to know why he's being such a dick? He's represented thousands of police officers at interviews before he became a judge. He's a cop lawyer. Now you're surprised? He just told you. See what's happening here? I'll let you hear that again.
Incriminating information.
Who's made that finding? That's an interesting concept because I probably represented thousands of officers at interviews, and I yet to have or even hear of someone making a determination that that person had a Fifth Amendment privilege or not. My experience has been that the department offers people a rights form, and if the department has made or ascertained that the person has a self-incrimination right, far be it from a lawyer to question that when the prosecuting or investigating agency is doing that. So again,
it's built into the law of the Fifth Amendment, Your Honor, that you can only take the Fifth Amendment when a truthful answer will incriminate you.
That's assuming you're ordered to, and that's assuming that the order also encompasses the nuances presented by the state constitution, which requires transactional immunity to overcome it under Carney versus Springfield. So it's not as simple as you make it sound. But let's get back to the fundamental issue. Does the district attorney's office keep records of any officers that have ever invoked their rights at any proceeding that the district attorney's office is aware of?
No.
Okay. And if, with regard to the police department, Mr. Bradl, I'm not aware of whether they keep records of that or not, but I am certainly familiar with the fact that even if that were true of a particular officer, it certainly is not admissible.
Judge Grant McFarland has a whole host of things that are not admissible, or an optimistic defense counsel
Right.
might say not yet admissible, but that's not a exclusionary factor, Your Honor. So you can't really go there. And these are all, we don't need to pretend like the officers are in Alaska. They're down the street.
No, I understand.
Commonwealth can ask them all these things.
But does that case say that all records pertaining to an officer, any officer who has ever invoked his or her rights, either under the Fifth Amendment or Article 12, records have to be kept and they have to be disclosed? Does the case address that?
It does not say anything about
Does the case address whether or not an officer who is the subject of a pending internal affairs investigation unrelated to the matter that is before the court, that those records need to be produced?
Yes.
Okay. And what about whether the officer has ever testified in a motion to suppress, which the motion was allowed because the officer violated? It's pretty broad in terms of violating the defendant's rights, but assuming we could refine it a little bit,
Sure.
Does the case say that you must produce that? And who's charged with keeping those records?
Your Honor, Brady says we have to produce that. The Constitution says we have to.
On any motion to suppress that was ever allowed?
If an officer is found to be not credible,
Well, see, we're talking.
Well, hold on. Those are two different things here. The fact that a motion to suppress is allowed does not necessarily mean that an officer was found to have lied or made false statements. There are two different things. People make mistakes. The purpose of the exclusionary rule is to deter police conduct, but not every motion to suppress is allowed because a judge finds that an officer lied. Yes, the motions are allowed because in the court's judgment, for example, a stop was unjustified, but that doesn't mean that the court found that an officer lied.
that's.
In fact, I'd say most of the time that's not the case.
We're not talking about a legal ruling about an officer's conduct. We're talking about when an officer's been found not credible. And that's what we're looking for, Judge.
Well, does your office keep records of decisions by judges saying that officers made false statements or are not credible?
Yes.
Okay.
And so,
Yeah.
and he's being cute because what he's writing in this motion is much different than what he's saying.
Stop. Did he just say he's being cute? Hold on a second. They do keep the records, so what's the big effing deal? Hold on.
Decisions by judges saying that officers made false statements or are not credible.
Yes.
Okay.
And so,
Yeah.
and he's being cute because what he's writing in this
He's being
motion
cute.
is much different than what he's saying here.
Did you check the database for what I just outlined?
Yes, and we asked these officers, and he knows this, we asked these officers a whole host of questions.
Okay.
About whether they have convictions,
Sure.
facts about criminal offenses, I'll just adverse credibility findings against them from any court.
Okay.
Pending criminal investigations into your conduct, findings that you have engaged in bias, racial, or
Okay.
profiling, discrimination.
Okay.
crime, findings that you have engaged in untruthfulness or misconduct implicating credibility.
And have those questions been asked of the witnesses in this case?
Yes.
And have you provided any information that's responsive to those questions?
They're so
What's the complaint, Mr. Bradl?
Well, that's what I'm asking, is if it's complied with. And
You just said it was.
I'm saying it was, and counsel got up and seemed to be wanting to correct me on that. And so here we are.
Okay.
So is it complied with or
Well, it's
not?
on the record. What else do you want?
The motion speaks for itself, Your Honor. I just want to know what the Commonwealth is objecting to.
Well,
They gave us a list, and we can go through it.
the list of questions that you asked?
Counsel objected to 2C, have they ever refused to answer questions citing their constitutional rights? We had a little bit of a debate about that. I think that's, Judge, a firing offense. I believe that assistant attorneys general have been fired for that. I believe officers have been fired for taking the fifth.
Really?
I think it's
In the absence of
exculpatory.
transactional immunity, officers have been fired?
I think it's
You should read
exculpatory.
Carney versus Springfield, and I think you'll find that you're incorrect.
Well, Judge, I think that an officer that takes the fifth in this case about something else is saying, if I answer that question, a truthful answer will incriminate me. So
Well-
I think under Graham McFarland, I think that's certainly
The case doesn't say
exculpatory and
it.
discoverable.
The case doesn't say it. I don't agree with you. Carney versus Springfield says otherwise, okay? And I don't agree. So, Mr. Gubitosi, have you provided a list of the questions that you have asked to the officer, or can you, or will you provide the list of questions that you ask to defense counsel?
Of course.
Okay. And Mr. Bradl, if the answer to all of those questions is no, and they've asked them, I'm not seeing anything that would indicate otherwise in this case, then you need to examine the questions, and if you feel there's something that wasn't covered, then you can refine your motion. But I am not going to allow, and I don't think I agree with your view of the law, that whether or not an officer is refused to answer questions, citing constitutional rights is something that you're entitled to. In the immediate aftermath of critical incidents, officers often advantage themselves of the fact that the police department does not have transactional immunity so that they can have an opportunity to speak sometimes within 24 or 48 hours. Happens all the time. And in fact, officers are often interviewed thoroughly thereafter. So the case does not say that if you refuse to answer questions, it is fireable. In fact, it says quite the contrary. The police department does not have the ability to grant transactional immunity. Only the Commonwealth of Massachusetts, the district attorney's office, or the attorney generals have that ability. So to suggest that a chief of police or commissioner could fire someone for invoking their rights without giving them transactional immunity is incorrect. And so as to the extent you're asking for that, it's denied. Now,
The next one is D.
yeah,
Whether the officer is subject of a pending internal affairs investigation or any internal affairs investigations into the officer's conduct, whether these have resulted in sustained findings of misconduct. I'm not sure why there's an objection there.
Well, the way it reads is different than the way he says it.
Okay.
If there is a sustained finding, absolutely.
sure,
And,
okay,
and there hasn't been in this case.
okay,
With any of the officers that are involved.
okay. So that's the answer to that. And as far as the other questions, it seems to me H and I are covered by the questionnaire, but J,
Well, no, if I might just say, H and I, if you're gonna deny them, but they're different than what he's saying.
no, I is only, you only need to respond to I if there's been a finding by a judge that there was a misstatement in the search warrant affidavit, not whether or not defense counsel has filed a Frank's motion, because that happens routinely, and routinely the matters don't even reach an evidentiary hearing. And even if they do, it often doesn't result in a finding that there was any untruthfulness. So yes, if there has been a Frank's finding by a judge that an officer, any of these officers, made false statements in a search warrant affidavit, yes, you've asked about that, and yes, that has to be produced.
Of course.
Okay.
But H, if we can just get back to that, because we talked about that a little. And if the way counsel is talking about it, if there's been an adverse finding of credibility, of course we turn that.
Yes,
That's a no-brainer.
Right.
To do that.
But-
But that's not what that said.
no, not every, I am not going to order the production of any motions to suppress that were allowed for any reason. First of all, it's almost impossible to ascertain that. And secondly, how many district courts in this county, Mr. Gubitosi?
7.
7? Well,
Yeah, but you can ask the officer, Your Honor.
Well,
The officer is
he
right
has,
there. You
and
can
if there,
say-
I agree with you. If there was a finding that the officer made a false statement, you're entitled to that. But the fact that an officer thought that he or she had reasonable suspicion to conduct a pat frisk and a judge disagrees does not mean that the officer was found to be untruthful. But yes,
I agree with you. We don't
in the
need to-
course
we don't
of,
need to debate it. I agree with you.
okay, so I think we're fine. Now, Jay, you know,
I just have no idea.
I have no idea what that is.
Okay, and then they can answer that. They don't know about it, they don't know about it. That's the answer. I'm happy with that.
Okay. Now, is there, Mr. Gubitosi, when did you get meeting 35, the motion for specific discovery?
Friday.
Okay. Are you prepared to respond to it?
I can try to,
Okay. Is there anything in there that you object to?
yes.
Okay, and what is that?
Again, there are portions of number 2. And the Commonwealth will provide all witness statements.
Okay.
As pursuant to 14, this is overbroad.
Okay.
Number 4A, excuse me, 4 is asking for any and all footage from the North Andover Police Department on June 30th during the time of which Ms. Fitzsimmons was at the station. And we've already talked about that. They asked me a bit ago. They didn't ask me in time, so the footage is gone. But
Oh, I'm sorry, what?
doesn't save longer.
They didn't ask me in time, so the footage is gone. Here's what number 4 is requesting. Any and all video footage from North Andover Police Department on June 30th of 2025 during the time in which Ms. Fitzsimmons was at the station for her CPR recertification. That's the same day of her shooting by another cop. The names and contact information of any officer that interacted with or observed Ms. Fitzsimmons at that time. Did they think that that would not be relevant? That she had been to the North Andover PD on the day of her shooting for her CPR recertification? Yeah, it's already gone. We don't have it. Hold on. I want to hear that again. Yeah, they have to preserve all evidence. Prosecutors have a duty, but not here. They don't.
Any and all footage from the North Andover Police Department on June 30th during the time of which Ms. Fitzsimmons was at the station. And we've already talked about that. They asked me a bit ago. They didn't ask me in time, so the footage is gone. But it just doesn't save longer than I think it's 30 days.
Okay.
Oh,
If
they have a
something doesn't
30-day
exist, then,
But the
They have a 30-day overwrite on their footage, just like Canton PD. But then we found out after Karen Reed's first trial that it really didn't overwrite within 30 days because all the footage started to magically reappear. Have they learned nothing from the 2 persecutions of Karen Reed in the state of Massachusetts? Really? Really?
But it just doesn't save longer than I think it's 30 days.
Okay. if something doesn't exist, then.
But the last paragraph, the last sentence says, the name and contact information of any officer that interacted or observed Ms. Fitzsimmons at the time.
Okay,
Well, she has that information. Who she interacted with on
Right.
November 30th of 2025 at the station, so.
Ah.
That's something
well,
that-
first of all, maybe I'm missing something, but other than in the interview room, when someone's advised that they're being recorded and you know, they're taped, I'm not sure there's,
No, I think this is, she didn't go to the PD after the event, she went to the hospital.
okay,
For the event, it's my understanding, and this is only from what defense counsel told me.
Yeah.
That she was at the station earlier that day.
oh, okay.
Had done on something, I can't remember what, during the day.
Was at the station earlier, Mr.
But she
Bradl?
knows who she interacted with.
Okay, is June 30th the date of the incident, by the way? Okay. And when was she at the station and for what purpose? What time does the incident happen?
So Your Honor, the incident is, it's in the afternoon of the
Yeah.
30th. And prior to that, Ms. Fitzsimmons was at the North Andover Police Department for a CPR recertification.
I see.
She brought the baby with her.
Okay,
So we wanted the video
Yeah.
from the station. And on August 26th, I think the Commonwealth's going to have an issue with this, okay? On August 26th, we filed these arraignment motions.
Right.
Asking, we put them in abeyance except for some of the more obvious ones like
Right.
preserve notes, preserve video.
sure.
Tell people who are video holders to hold on to the video. That was August 26th. So the
Okay.
Commonwealth was on notice as of August 26th.
Yep.
The video, I am fairly certain, was present and available then when they were given notice of this motion, and I believe the court allowed those preliminary requests.
Well, there are two issues there. First of all, though, when you say August 26th, was that filed in this court
Correct.
when she was arraigned?
Yes.
Okay. And Mr. Gubitosi, do you know, first of all, I don't know because not that familiar with the North Andover police station, whether or not they even have cameras that would have videoed the presence of the defendant at the station on that day.
They do.
Okay. And do you know how often those are recorded over?
Not at the present time.
Okay.
I did. When we spoke about it, I called.
Back in August?
It was gone. I can't remember.
Okay, okay. So the issue then becomes whether or not the request was made. First issue is whether or not you're confident the video doesn't exist today.
Correct.
Okay. The first question is,
I just want to interrupt to remind all of you that this incident to which they refer was a shooting of a cop by another cop. This judge has made it obvious. He's told the world and you and me and everyone that he, when he was in private practice, was a cop's lawyer. That's what he did. He represented thousands of cops who were interviewed. And the cop that I think he's trying to protect here is not Kelsey Fitzsimmons, it's Noonan. And I also want to remind you that this incident, this shooting, happened not even 5 months ago. This wasn't years ago. This was June 30th of 2025. And Bradl is saying, when we discussed this in August, and I'm assuming it was in front of the other judge, McCarthy Neyman, they told me they had the footage that it existed in August. So if they had it in August and I asked for it back then, why does it all of a sudden not exist now? Moving on. And he just said he's confident it doesn't exist. I'm just going to rewind this a little tiny bit.
issue then becomes whether or not the request was made. First issue is whether or not you're confident the video doesn't exist today.
Correct.
Okay. The first question is, I think that the defense counsel's entitled to know when the video, how often they tape over. I mean, I hear,
I did tell him that.
right,
When I found out, I just can't remember right now.
but you can,
I can just suggest, Judge, if I
Yeah.
may, I looked at, and counsel's trying to accommodate, so I
Right.
appreciate that. But on 9/18, counsel told me that they only had it back to July 5th,
okay. And you made the request on,
8/26.
right, but that doesn't answer the last question, which is whether or not at the time you made the request, it still existed or not.
Right.
But
I-
Mr. Gubitosi, that should be easily ascertained.
Absolutely.
Sure,
I
okay.
think if you do the math, it looks like it is, and again, I appreciate the Commonwealth's efforts to try to get it, but it looks like on
Yeah.
8/26, if you do the same math, 9/18, it goes back to July 5th, 8/26, you're going to be within the window of.
You may, I don't know. I don't have, every video system that I've ever heard of, I've seen some that go 3 days, 7 days, 30 days, I don't know. But that's easily ascertainable, and Mr. Gubitosi is going to tell you about it, and then you can make of it what you need to make of it.
And there's no motion before the court on
Yeah.
it. I just wanted to
Okay.
bring it up, Your Honor, that it's very important to the defense that we have that
All right.
video.
Anything else we can, in this motion, Mr. Gubitosi, that you object to that we can address today?
Yes, I think we have.
Please, yeah.
The judge's name is scrolling along the bottom of your screen, if you're curious.
Number 6 is concerning disciplinary records for firefighters that responded to the home address of the defendant or Mass General Hospital.
And your objection to that is?
So the firefighters are not part of the prosecution team. If they're not in care, custody, control.
Yeah. I mean, you can file a Rule 17 for that, Mr.
Very good, Your Honor, that's perfectly
Bradl. I
fine.
think that's right. What else, Mr. Gubitosi? Anything else in this motion?
Number 9.
Yep.
All statements, including text, emails, voicemails, writings, or like between or among any civilian witnesses, police or prosecutors. I would just say it's overbroad.
Yeah, how, Mr. Bradl, how can the Commonwealth produce messages between people who are not, civilian witnesses?
Sure, I understand, Your Honor. The request should be really a little narrower, I suppose, which is whenever there's a police prosecution team member in the conversation,
Well,
then
that's
it should
different. I
be
agree.
discoverable.
Right.
So
So statements, Mr. Gubitosi, of people who are,
Are statements that
yeah.
I'm obligated to provide in Rule
Yeah.
14, absolutely.
Okay.
I agree with that,
Okay.
but not that.
and just, oh, sorry, go ahead.
No, I was moving on.
Just one thing on that before you move on, Your Honor,
Yeah,
is
sure.
that,
Yeah.
it's our view, we viewed on the security video from the scene that officers are texting and calling all over the place at the scene, quite understandably.
Sure.
But we just want the text messages, and we have information that there were communications between the father of the child and the police officers leading up to serving this warrant, leaving up the restraining order, rather, serving the restraining order, leading up to that. And
What did I say yesterday? I said, I bet you he was waiting around the corner because he lives in Stowe and she was in North Andover. Unless he was at work, they probably had him waiting around the corner to come and get the baby. And he wants those text messages.
there are communications that are between the father and the
Okay.
police that we want,
Well, if
which would
any
certainly
of
be
those
statements.
materials that are in the possession, custody, or control of the Commonwealth or the North Andover Police Department need to be produced. I can't, it's a little bit broad in the sense that, if there are people texting that the Commonwealth doesn't know about. it's
I
kinda hard
agree,
for them.
Judge. I don't even want to, yeah, I can cut to the chase on that.
Let me
Statements
suggest
that involve the
something
police and prosecution team.
here. I'm well aware of the fact that there's some discovery issues here, but they don't seem insurmountable to me. And they seem like something that could be worked out. The defendant's in custody. You are and have, as is your right, litigating the issue of her detention. And my solution to that, it's not my decision one way or the other, but it's in front of the SJC. But I feel that this is the type of case that is tried in the district court every day. It's a serious case. All cases are serious, but it's not complicated. And I want to set a trial date sometime early next year, and we'll get another discovery compliance date in a few weeks. Mr. Gubitosi starting a trial December 1st. So maybe in late December, we can have another compliance date if it works for everybody to try to iron these things out because, you know, it's, she is in custody. I'm cognizant of that. And so my solution, whenever, and we deal with this all the time, we spend sometimes more time dealing with the issues of pretrial conditions and release. And in the time we spend doing that, we could try the case. So this case looks to me, and I could be wrong, that it could be tried in a couple of days. And she's in custody. So if the case is tried and she's found not guilty, that's the end of it. If the case is tried and she's found guilty, that's a whole other issue. But the fairest thing, it seems to me, is to try the case as promptly as we can. So before your schedules get any more backed up, I want to set a trial date. You can always revisit it, but what about sometime in late January, February?
That's very fair, Your Honor, and I appreciate you saying that. And I wanted to ask maybe the first week of February.
Sure. Mr. Gubitosi, how's that work for you?
I have a murder starting on the 26th of January, so if we can go to, I could do this the week of the 9th.
Okay.
That's fine.
Does that work for you, Mr. Bradl?
Yes.
Ms. Attorney Coakley?
Always with the caveat that I haven't checked with any witnesses.
Of course.
Sure.
And but this way we have a target date. Everybody can check with their witnesses. We can find out and iron that problem out now. And if there's somebody who needs an adjustment for a few days, a week, one way or the other, we can work on that. But the longer we wait to do it, the more backed up we get. And again, you know, we're going to prioritize this case. She's in custody. Maybe she will be at that time, maybe not. I don't know. But at best, for your client, she's going to be on restrictive conditions, and that's a factor as well. So let's get a trial date now. Let's shoot for that. We'll schedule it for trial on February 9th. I think that's very reasonable. And let's set another discovery compliance date that everybody can live with sometime in December. Mr. Gubitosi, you expect to be tied up for a couple of weeks?
Yep, I think I can, the week of the 15th, I should be.
Okay.
I was going to ask for maybe the 18th along those lines. I think we're in the same
That's fine.
process.
We can do that. Sure. We'll do the 18th. And my purpose that day,
Sorry, Judge, just a calendar issue. I'm sorry.
okay, all right.
Judge, 18 is a tough day, it turns out. Could we do the 19th?
I'll do it.
Okay.
If Mr. Gubitosi is available. Okay. We'll do it. Now, and I want you to have a conference, which I know you will, to see if you can work these things out or refine or narrow the motion. And we'll revisit those things that day. I have a Zoom that's coming from a different Norfolk that we have to get to right now. So it's either that or we get together late this afternoon.
Perfectly fine, Your Honor.
Okay.
I think we can resolve much of the rest of it.
Now, as far as your request, the last thing I'm going to cover is your request regarding transportation of the defendant. I allowed it today. I'm going to do it on a date-by-date basis. I mean, if the next date is discovery motions, I don't think that it's necessary to transport her. If you want us to try to do a Zoom, we'll attempt to do it. But the goal here, again, in fairness to the defendant and everyone else, is to get the case tried promptly. So we'll have a hearing that day. I'll try to, or me or someone will iron out all of these issues if we can, and let's keep moving. I don't expect, doesn't sound like you intend to litigate a motion to suppress in this case.
Correct, Your Honor.
So that removes one common obstacle to getting this done. So working with that, I think everybody's being reasonable in terms of time. Why don't you have a further conference, exchange written?
Motion to suppress. What is there to suppress? There's no evidence. There's no body-worn camera. They got nothing.
Responses so that there's, down the road, there's no misinterpretation. And let's see each other again in a few weeks. And I'll order a Zoom, Habe, if we can do that.
Thank you, Your Honor.
Okay?
If-
All right.
I think that'll be fine. If there's any issue, we'll file appropriate case.
And if you have a narrower motion, or you can narrow the issues, file another motion, and I'll make sure that I get a look at it, or somebody will.
Thank you, Your Honor.
All right, thank you. Have a great holiday. All right.
Thank you, same to you.
Have a great
Okay.
holiday, except for Kelsey, who has to go back to jail in Chicopee. She just
Judge,
said, I
does
love
that
you to
mean 12
someone.
noon As well, the same thing, or does that?
My boss has to tell me that right here. Okay, she says noon, then that's, we'll do it. Okay.
Welcome to Zoom. Suffer.
Let's watch Kelsey do her walkout. Bradl.
Enter your participant ID followed by pound.
Is Tom CPU outside the courthouse? Is he going to do any interviews outside?
You
Does
are
anybody
in the
know?
meeting now. There are 2 participants.
Yeah, we don't need to see that. What a mess. What a mishigas this is. What an absolute disgrace. Hang on a second. Is Tom CPU live? Hang tight for a second. Okay, I don't see him there. Wait, Tom. I think that's far for him, isn't it? She did. I saw her mouth. I love you. I think it was to her family. All right, what did we learn? What did we learn today? Today we learned that that this judge, before he became a judge, was a cop lawyer. We learned that. He did thousands of interviews with cops, and it seems to be pretty obvious whose side he's on. And then we noticed a demeanor shift when he found out that the Commonwealth may have destroyed evidence of the video that apparently did exist, but may have been overwritten from 30 days. Every 30 days or so. He doesn't really know, Gubertosi. Gubertosi doesn't really know. Well, I'm not going to stream anybody else's stream unless they specifically said that I could stream their stream, and Tom CPU is cool about it, so we can go look at that later. Amber says, I bet they're trying to break her by keeping her locked up. If she please, it's over. If not, it'll be a whole episode. Thanks for your 5, Amber. David says, did you read in his statement where Justin said he heard 3 shots and he was so scared that Kelsey was going to shoot her way through the police and come after him that he ran away? I think we did read that, David, in one of his statements. I think we did. Thanks, David, for your 10. Kentucky says, how it works for medical. Kelsey has a problem. She tells the CO, who either calls medical or tells her to go to sick call in the morning. Thank you for your 5 from what I'm assuming is Kentucky. Casey Cat said, poor Kelsey can't seem to get a break with these judges. Thank you for your 5. Hit me with your best shot says, my name got changed. Hope you remember me. I can't with this judge. Why are you trying to ruin Kelsey's life? Shame on him. Mental health classes should be mandatory on how serious postpartum is. Yes, Manj, thank you very much. Your 10, I appreciate you. Resisting arrest, thanks for being here for 11 months and for your opinion that the judge is a bit of a snot, isn't he? MS 808, thanks for your 5. Watching the Commonwealth cover up in real time here is actually wild. Isn't it? Technical Ad says, wow, just another terrible jurist. And this is another county, right? Yep, this is Essex. What is happening in Massachusetts? I don't know. It seems to be why we can't seemingly get out of this state. Although we might have found another state, Arkansas, where the judges in Arkansas are saying, hey, McCarthy Neyman, hey, Cannoni, hold my moonshine. Check this out. Thank you for your 10. Allison is outraged and she was rage dusting plants. Thank you for your super chat from across the pond. Hello, the good dog says, are we in Russia? Defendants stand behind glass and do not receive fair trials in Russia and Massachusetts. Hashtag outrage. Yes. In fact, at the beginning of the hearing, Tim Bradl said, Your Honor, would it be all right if my client sits at counsel table? And the judge says she doesn't have a constitutional right to that. She has a right to be here, but she doesn't have a right to sit at your table. And the answer is no, because if I make an exception for her, I'm going to have to make an exception for everybody. And he didn't want to do it. Not taking her medical condition into account at all, because, you know, here we are in the upside down, inside out Narnia of Massachusetts. And sometimes we put Chaka up in the corner over there because it's the land of the lost. If you get the reference, you're probably Gen X. Ms. 808 says, sorry, I couldn't hold back. Justin, if you're watching, may your turkey be the driest and may you have limited access to water. Thank you for your 5. And Eric Clark says, dehumanizing language, judge referring to Kelsey as defendant. I didn't watch the whole thing because his attitude and his tone sucked. Thanks for your 20, Eric. Casey Cat says, can they appeal the bond hearing? Well, that's what's going up to the SJC. They're trying to have the SJC full panel. They appealed it to the single justice. And it is Bradl's position that that single justice was supposed to look at the issue de novo, meaning look at it fresh, instead of just deciding whether or not Judge McCarthy Neyman abused her discretion. And that judge, single justice, did not do that. They then appealed to the 7-judge panel. And so now all the briefs are in, and we have read all the briefs, the latest of which was yesterday we read. And it will go to the 7-judge justice panel. They will start looking at it, I think, December 2nd. I can't remember now if it was December 2nd or 3rd. And I think oral argument is waived or not happening. Although Tim Bradl did waive a reply brief, so he will not be filing a reply brief. Thank you for your super chat. And Stephanie says, why so much corruption? People who live in Massachusetts will tell you, Stephanie in Canada, thanks for being here for 23 months, that the corruption in Massachusetts has been going on for decades. This is not a new problem. It is only that there has become a focus on it worldwide, maybe because of the Karen Read case. Absolutely because of the Karen Read case, because the world became interested in the Karen Read case and watching the corruption and the framing of an innocent woman, because John O'Keefe was not hit by a car and a car did not hit John O'Keefe. And since then, so many other cases have come to light because, again, if this has been going on for decades, there are other cases that are affected in other counties as well. And I like to say that the tentacles of corruption in Massachusetts are so deep and so twisted, but it's always been there, I think. And I live in New York. You guys in Massachusetts can tell me what you think. Tell her what you think. Karen D, thanks. Happy holidays, 23 hours in, 1 hour out. Thanks for being here, Karen. And Crystal Ray says, we'll get you through this, Kelsey. We love you. Thanks for your super chat. Kelsey's fundraiser is pinned in the chat. Every dollar counts. Madam August Butterfly says, my husband's a police officer and they never delete body cam footage in a month, if ever. Well, they're not referring to body cam footage here because North Andover police officers do not wear body cams. What they're referring to, and we're going to look at the document in a moment, is any video from the North Andover police station from the date of the shooting, because Kelsey apparently was there earlier in the day for her CPR certification, and we found out she brought the baby there too. Thank you. James says, all these dinosaur judges need to retire. Thank you for your super chat. Or I think it says Jamie. Thanks, Jamie. And thank you, Cash Corgi, for being here for 18 months. You're an OG. And Sheila says, is there a way to change judges because of his obvious bias regarding police? I don't know that he's going to be the trial judge on this, but he did say, let's try this case as soon as possible. So, Mass Dad, I know you said that he may not be the trial judge on this, but it sounds like he wants to try this case. And it sounds like the trial date is going to be the week of February 9th. So it's coming up pretty quickly. And there's going to be a further compliance hearing December 19th, and they will only let Kelsey in by Zoom. They could make a motion for the judge to recuse himself. But in Massachusetts, when you move to have a judge recuse himself or herself, the judge you're asking to recuse themselves is the judge who hears the motion. Crazy, right? I know. They don't do it that way in Florida, because I think that happened in other cases that we were looking at in Florida. Maybe it was Sarah Boone, that a different judge will hear a motion to recuse. But we saw Judge Cannoni decide on the motion to recuse herself in the Karen Read prior to Karen Read's first trial. And she decided, I think it was the only motion that she decided from the bench. And she decided, no, I'm not recusing myself. So seems crazy, but that's the way they do it in Massachusetts. Thanks for your 5. Husky Lover says, this is infuriating. Thanks for being with me for 20 months. And Sint Goddess says defendants relying on FOIAs from the public to get discovery is the new Massachusetts norm. Yeah, we're seeing a lot of that in the Karen Reed case and in Aiden Carney's case, in that Corey Hopkins and other people who are doing FOIA requests, Freedom of Information Act requests, or public records requests in Massachusetts are getting emails and other records that have been requested in Aiden Carney's case that they can't get from the Commonwealth, but the records clerk is releasing them to the general public. And yeah, it's crazy, but that's what's happening. Thanks, Sandy, for your Venmo. Thank you very much. She says North Andover PD has cameras in every hallway, in every room. The question is, though, Sandy, does it overwrite itself every 30 days? Because that's what it seems. Well, it seems like Mr. Gubertosi, the ADA, doesn't know how quickly it does actually overwrite itself, but I guess he's going to find out. And I guess there's a question about whether or not this video did exist, and now all of a sudden it doesn't. And then there was a backpedal and abada. Kyla, thank you very much for your memo. Says happy Thanksgiving. And she is in Arkansas and will be in Cabot, where the Aaron Spencer issues are happening. Well, girl, if you want to go to the hearing on Aaron Spencer, I guess it's not as close to Christmas as maybe you will be there, but the pretrial hearing, hang on, for Aaron Spencer is going to be in Lonoke County, and that is going to be in or on December. Hang on. December. Well, it was in my calendar, but now I can't find it. Oh, 17th. December 17th. It's a Wednesday. So if you're going to be there, go check it out, because you can bet that there will be no cameras in the courtroom, because they don't do that in Arkansas, from what I understand. Let's take a look at the latest motion from Tim Bradl. And some of these things they were arguing about in court. This was just filed on Friday. So hang tight while I pull this up. Some interesting stuff in here. And this is Kelsey Fitzsimmons, defending Kelsey Fitzsimmons' motion for specific discovery. Some of this stuff they discussed in court, some of it they didn't. Number one, they're looking for all evidence of promises, rewards, or inducements given or offered to any civilian witnesses, including but not limited to Justin Aylaian, Brendan Aylaian, Ashley Aylaian, Courtney Aylaian, Lisa Aylaian, Douglas Aylaian, North Andover Community Support Coordinator Crystal Clooney, Deandra Davis, Cassandra Mazzone, Katrina Caruso, and Michelle Mitchell. It looks like these are all civilian witnesses in this case. Some of them may have given affidavits to Justin when he went in to get his ex parte restraining order against Kelsey. They may have given affidavits in some of the family court proceedings involving custody. And that is my guess, that they gave witness statements. Not only are they Justin's family members, he's the baby daddy, or the father of Kelsey's child is Justin Aylaian, her former fiance. Lisa and Douglas, we know, are her parents. And it looks like the other three may be his siblings. Some of the others may have given witness statements with regard to his ex parte petitions. I don't think he had any issues with that one, the ADA. Number two says all statements of any witnesses known to the Commonwealth, regardless of whether they are intended to be called in the case, including but not limited to those contained in grand jury minutes, text messages, whether on department or personal cell phones, emails, voicemails, notes, writings, and the like, made by, between, or among any and all police officers, civilians present, and or firefighters or EMS personnel who responded to Phillips Brook Road, that's Kelsey's, it was her house, I believe it's been sold, on June 30th of 2025. That's the day of the shooting. Defendant requests the same information from any further witnesses directing or managing or otherwise involved in the police response and investigation whether intended to be called or not, by the Commonwealth, who were not physically present at the incident at Phillips Brook Road on June 30th of 2025. And I believe that the ADA said, well, if it's in our custody, possession, and control, we're required to turn it over. We know that, and we will. And so that, after the video, well, let's get to the video. Number 3, Corey records, current address, phone number, and date of births. Dates of birth of all civilian witnesses. Corey is a criminal background check. They do it on jurors in Massachusetts as well. Number 4, any and all video footage. This is the one they were arguing about, that they said the video doesn't exist anymore. Any and all video footage from the North Andover Police Department on June 30th, 2025, during the time in which Ms. Fitzsimmons was at the station for her CPR recertification. The names and contact information of any officer that interacted with or observed Ms. Fitzsimmons at that time. And then I think the ADA said, well, doesn't your client have that information? And again, I remind you, she was shot in the chest. She was airlifted and clinging to life for quite some time during her 53 days in the hospital and undergoing 5 surgeries. Maybe her memory's not that great. And really, is it that much of a burden for you, ADA, to ask your officers? And then they had the scuffle about whether or not that video still exists, whether it did exist at the time he made his initial request for it in August, which was only a few weeks, less than 60 days after the incident. And that is when first the ADA said, oh, every 30 days it overwrites itself. Then he changed, he pivoted, and he's like, oh, I'm not really sure. Because if it's every 90 days and they made the request on August 26th, it's going to be a problem for them because it did exist. And now all of a sudden it just doesn't. Hang on a second. Well, Tommy's outside the courthouse, but he doesn't have anything up on his camera yet. So hang on. When they come out, I'll pull to that. I'll break to that. Okay. Okay. For number 5, they would like any and all training records for Lieutenant Sean Daly, Officer Timothy Houston, and Officer Patrick Noonan. Those are the 3 officers that responded to the scene to serve. Oh, he's at Cape Peters court date. Thanks, Michelle. Okay, well then that doesn't help us. That doesn't help us. I was hoping you would get some courthouse steps interviews. Thank you for telling me, because I would have to listen to that in my ear until they came out. Okay, cool. Thanks. Sorry for the confusion. CPU Mod 1 is here. And that's Tom's CPU sister. These are the 3 officers who responded to Kelsey Fitzsimmons' house to serve her with the restraining order and the take away the baby order. Sean Daly, Timothy Houston, and Officer Patrick Noonan. Number 6, any and all disciplinary records for any officer or firefighter who responded to Phillips Brook Road, North Andover, or to Massachusetts General Hospital on or after June 30th, 2025. The ADA said, well, we're not in charge of the fire department, so those records are not within our custody and control, and so we won't have those. And Tim Bradl said, agreed. I'll make a Rule 17 motion for those. Rule 17 motions in Massachusetts are motions for third-party discovery from third parties who are not involved in the case. We saw a lot of those in the Karen Reed trials. Number 7, complete disciplinary and training records for Officer Patrick Noonan from North Andover Police Department and Lawrence Police Department. Number 8, complete personnel file for Officer Kelsey Fitzsimmons from the North Andover Police Department and any documents reflecting any complaints or demands for any type of relief made by Ms. Fitzsimmons against the department or in relation to her employment at the North Andover Police Department. Number 9, all statements, including texts, emails, voicemails, writings, and the like between or among any civilian witnesses, police or prosecutors, and Justin Aylaian, Courtney Aylaian, Ashley Aylaian, North Andover Community Support Coordinator Crystal Clooney, or a written summary of the statement pursuant to Rule 14. That is when we started talking about how we thought Justin might have been around the corner, and Tim Bradl did say that there were communications between members of Justin and or his family and police officers responding to the scene, and or I'm not sure if he said Kelsey's family and or police officers as well. Number 10, any and all information relative to any witness officer being placed on a Brady list for alleged misconduct and any prior instances of police misconduct. Number 11, any and all phone records from witness officers, including Chief Gray, the chief of North Andover PD, Officer Eric Suwade, S-E-W-A-D-E, and Officer Tyler Thomas via phone extraction and not screenshots for communications relative to Officer Kelsey Fitzsimmons and or the incident that occurred on June 30th, 2025. I didn't hear them arguing about this. But we know, if you've been following this case with me, that Kelsey had just been cleared to return to work after medical leave for postpartum depression, that she had just had her weapons returned to her, that she had to file some sort of action to get her weapons back, and that Chief Gray may have had some beef with her. We're not really sure about that, but if there are text messages that may shed a little bit more light on that. Number 12, any and all police reports, log notes, radio communications, 911 calls, or written communications relating to any calls for service at Phillips Brook Road from November 2024 through the present, including the incident that is the basis for the charge in this case. Tom is not there. From what I understand, he's at Kate Peters' hearing, because that's the title of the stream. But I could be wrong because I see Tim Bradl outside. So just hold on a second. Then why is his stream entitled? All right, let me hear if I can. Let me see if I can how the audio is. All right, we're a little bit behind. So let me just finish this document and then we'll flip over to that. "13, any and all text messages, voicemails, notes, or emails between any responding officers and Justin Aylaian for the last 2 years, November 2023 through present. 14, any and all documents related to any trainings relative to use of force, domestic calls, mental health related calls, service of restraining orders, and taking custody of children that any witness officer has attended. A list of any such trainings offered or conducted by the North Andover Police Department, regardless of whether or not responding officers attended such trainings for the last 7 years. Any and all policies and procedures of the North Andover PD relating to any of the aforementioned categories." We have said for a long time that we didn't think that the way they conducted this service of the restraining order and taking away the baby was proper procedure. So let's see if they've ever been trained. That'll be interesting. 15, a complete copy of the surveillance hard drive seized from the home of defendant by Massachusetts State Police. Well, that's interesting. The MSP seized Kelsey's home surveillance hard drive. Are you surprised? Defense team will provide a blank hard drive to the Essex County DA's office on or before November 25th, 2025. We've seen how that's turned out when the MSP has seized hard drives. Ask Paul Fahey, who's been convicted of the murder of Keith Boudreaux in a Quincy bar all the way back in like 2016. That's when, Colleen Crawford and John Fanning went in there and stole the hard drive. And then Paul Fahey, the defendant, argued that they edited that video. Number 16, all other Rule 14 automatic discovery and exculpatory evidence not already requested, such as search warrants, radio transmissions, 911 calls, reports, statements, video, diagrams, police logs, photos, surveillance footage, and the like. Number 17, an opportunity to inspect all physical evidence and potential exhibits in the case. I'm aware, KLM. I just said I would cut to it in a moment. Can I finish what I'm reading first? Would that be okay with everyone? Can I do it my way? If you would like to go watch it, please go do that. 18, any and all information responsive to defendant's arraignment discovery motions filed and served on August 26th of 2025. So there are two motions from August 25th that I don't have right here with me at this moment. And those are the motions that they were arguing about in the beginning, about all of the officers who are on the Brady list, who have ever pled the fifth. And that's when the judge got into a peeing match with Tim Bradl. It was outrageous. You for real, says Jackson, should take this case. I think that Kelsey Fitzsimmons is in the best hands being with Tim Bradl. Do you think this judge would actually look kindly on a lawyer from California? I don't. Yeah, and Jackson does have his hands full. And I like Tim Bradl. I think he's doing an excellent job. I think it's very unfortunate that the judges seem to be treating him with complete and total disrespect lately. It's a very fine line. People are saying, I feel like Bradl could fight harder. It's a very fine line because if you're fighting harder, your client gets thrown back in jail in Massachusetts. Did you listen to the hearing with me of Judge McCarthy Neyman? So you have to show respect, and I think he is doing an excellent job. And I'm absolutely in no way going to, in any way, criticize what he's doing for Kelsey Fitzsimmons. So if that's what you want to do, I'm not saying that's what you want to do particularly, but you're in the wrong place. There you go.
Take your time. You got everything. So you don't go first. I'm just going to take a lead here. You seem to be asking a lot of questions about.
Yeah, I mean, the volume on this is super low. Let me see if I can get it up anymore.
So just before we get to that, I just wanted to make one statement that we feel we made some progress in discovery.
Yeah, I can't. This is boosted at its highest level.
We believe he's innocent, she believes she's innocent.
And it's kind of unwatchable.
So we are working closely and we're confident that we will get there.
Sorry.
There's a lot at
That's
stake
Martha
for everybody.
Coakley speaking. Can you even hear it?
And you can see the judge understands that.
Young Jerks has clear audio. I'm not gonna restream Young Jerks. If you guys want to go there and watch it, you can. But based on current events, that is not something that I'm gonna do.
Discovery's ongoing.
The audio, I'm sorry, but that audio wasn't great. And so I'm not going to play it. Okay. All right. Let's take the rest of the questions. And then I'll release you all from class so that you can go and watch that wherever you want to watch it. I'm sure that Justice Served at 6 p.m. will have it because if Michael's there, he always has really good audio and really good video. And they have their show at 6 p.m. They don't do it live. So you can see it then. Kate the Great says the rule requires disclosure of all items and information favorable to the defense, broader language than the previous exculpatory evidence standard. That's right. Rule 14 was rewritten after Karen Reed's first prosecution. And guess who was the head of the committee to redraft Rule 14? Judge Beverly. That's right. That's right. Cammie said earlier, I just got here. Is there a reason that Kelsey has to stand on the side? Given her medical condition, I wouldn't think it would be very comfortable. Well, the judge said, you can go back and listen to it. At the beginning of the hearing, the judge said she doesn't have a constitutional right to sit at the table. I mean, she can be here, but I don't have to let her to sit at the table. And if I make an excuse for her, if I make an exception for her, I'm going to have to make it for everyone. And so he just wouldn't let her. He has the discretion to allow it, but he just didn't want to. Tony Marie says, it was interesting to see a demeanor change in the judge when he realized evidence had been destroyed by the authorities. 100%. 100%. You picked that up. You picked that up. Nothing gets by you guys. Nothing gets by you guys. Melissa says, trials don't usually start that fast. Do you think they're pushing it fast so defense won't have enough time to uncover and prove the corruption? Any info to put money on her books, not the defense fund? I don't. I have money. I have the defense fund, but the Give, Send, Go is going to, it is run by a family member, and it says, we are raising funds to help cover a variety of expenses, such as Kelsey's household bills while she is unable to work, and to assist her parents as they take time away from their jobs to care for her full time. Your donation will go directly toward household bills and living expenses, medical costs and therapy for her recovery, travel and time costs for her family so they can be by her side and support her, experts, investigators, and legal incidentals. Every dollar helps Kelsey get closer to her healing and having the healthy future she deserves. Thank you so much for your kindness, generosity, and compassion during this difficult time. Please share if you can. And the current number on the Give, Send, Go is $45,038. Thank you, Tony. Thank you, Melissa, for your 10. But also, Tim Bradl did not object to the trial starting in February because, God forbid, Kelsey's bail conditions are not changed and she has to remain in jail. It is better to get her out sooner than later, right? Thanks, Melissa. Kyle says Dallas had 30-day retention when we had analog audio and videotape. Went to 90 when first digital. Now it's a minimum of 1 year. See? Kyle was on the job in Dallas. He knows. I don't know if that's the way they do things in Massachusetts, Kyle. It's Wag says, Kelsey's son and I share a birthday, February 16th. If the trial starts on February 9th, I pray the trial's over and she's home with her baby by then. I'm hoping that the SJC will overturn her bail conditions and let her out. Thank you. Everyone, prayer hands in the chat for Kelsey. The milestones that she's missing with her infant over the past 5 months just break my heart. Mad World says, behind, but Maison's judge, typical behavior. Thank you, Mad World. Jeannie says, hi, I'm Pinky. YouTube will use our handles permanently to make it less likely for imposters. Okay, but I think there's a way to change it, somebody said. Maybe that's not true. I don't know. I don't know, Pinky, but thanks 3 of 5. KLM said, CPU. Actually, I don't think it was Tom that was doing the interviewing. I think it was, I think he was restreaming someone else's stream, but it was so low that nobody could hear it. So we pulled the plug on that. Casey Cat said Tom was using Young Jerk's interview outside the courthouse. They are live there. Thank you. I'm not restreaming them. Danielle said, my 3-month-old grandson is glued to my phone watching you. I said, she's pretty hot. And he smiles so big. Oh, that's so sweet. Hi. I love the babies. I have 5 kids of my own and I miss the infant stage so much. I love the baby stage. Bab says, would Kelsey's home insurance cover a lot of this expense? No. I don't believe that they would. That's a good question, but I don't think so. They may have covered any damage to the home, but they're not going to cover attorney's fees and other things. If there was any damage to the home, they might. Thank you, Bab, for your 10. And I think in song lyrics says, I was able to change my handle to my nickname. It works. It works. I don't know. It may also depend on what kind of device you're on, right? Thanks for being here for 14 months. You're awesome. Thank you. Thank you. Belinda, I can't do anything to unblock you unless you send me the link to your actual channel. You need to send me the actual link to your channel. Sarah said, I wish we had a magic courthouse bus for us all to free Aiden, Kelsey, and my future dad, Spencer. Oh, you're very welcome, Sarah. You're very welcome. Betsy, thanks so much for your Venmo. Says I'm outraged. Love you, Mel. Love you, Betsy. You're always so very generous to the channel. Sandy said, absolutely not, through another Venmo. You guys are awesome. Give me some more of your thoughts, questions, comments, and concerns, if you have any, before we wrap this stream for the day. Yeah, I know. Cindy says, Cindy RN, she looks so broken up there today, realizing she would not be there for the holidays. I know. Very upsetting. I don't think Kelsey's been decertified. I think she's just on leave from North Andover PD, right? Does anybody? I don't think she's been decertified. Right? Heavy Jet Flyer says, do y'all want Bradl to fight the judge behind the gym after school? JFC. When can we expect sidebars to come out? Some of them may come out within the next 30 days. I guess 30 days would be the latest that they would start rolling out. But aside from that, they need to be transcribed. And aside from that, the order said that they could come out in batches, I think. So she hasn't been decertified, right, Team Brittany? Exactly. Exactly. It's all good. Said, this is just sad. I wish we could bring her a miracle. I know. I know. And Ducky Grammy says, why are they so mean to her? What am I missing? I don't know. I don't know. There was a recent case, a civil case that went to trial regarding discrimination against women in the police force, I believe. And the verdict came down in Suffolk County. I think it was last week, $6.8 million. A lot of women in law enforcement in Massachusetts will tell you that they've been discriminated against for decades. Is that what's happening here? I don't know. I don't know. But that's what people think. Ms. Holmes wants to know if this judge today had the authority to amend Kelsey's bail conditions and let her out. No, he said the SJC has it now. So sua sponte, he just couldn't do that. The Commonwealth said in the brief that we read yesterday that it's been 10 weeks since they made their last motion to reconsider, and she must have healed by now. And so they could have made another motion to reconsider, but they didn't. And there hasn't been one made. But this judge, no, did not have that authority because there's no motion pending in front of him. It is now in front of the Supreme Judicial Court, and that's where it stands. Yes, thank you very much. DM Lady Di says, please send Kelsey some uplifting mail for the holidays to lift her spirits. If you would like to send her a letter, and she is receiving your letters and cards, and she's very, very grateful. It really keeps her going. In the show notes below is the address for you to send mail to Kelsey at Chicopee. It's got her inmate number. It's got everything. And so please send her cards and letters. And it is really helping her get through. It's really helping her get through. So please do that. There are also very specific rules for the mail, which I didn't cut and paste because it's so very long. But if you go to my Kelsey playlist, if you go back to one of the streams, like one of the earlier streams, it has the very extensive rules, which I will just remind you of right now, since we are talking about it. So hold on a second. There are certain things you can't send in the mail and certain things that you can send in the mail. So give me just 1 second to read them out loud to you while I'm thinking about it. But it's not on that one. Hold on. The rules are extensive. And so sometimes there's not even enough space for me to keep posting it in the show notes. And so I can't, but let me just see if I have them here. Oh, please. Well, I don't want to keep you holding too long. So if I find them, I find them. If I don't, I don't. One more place to look. Okay, here's the rules to the mail. All inmate correspondence is opened and expected for contraband. Inspected. All inmate correspondence letters must be written in black ink or non-colored pencil. So you have to use black ink. All paper that the letter is written on must be white in color, free of stains, spills, or discoloration, to include lipstick and perfume. I didn't realize that. I might have written a letter on a legal pad if I didn't know this. So you have to use white paper and black ink or non-colored pencil. Envelopes must be pure white. Drawings must be non-colored pencil or black ink. Greeting cards must be non-layered, no pop-ups or music devices. Only two-sided cards with no layers will be allowed. Photographs must be in the original form. Any alterations, including glue-like substance, tape, or tears on the photo will not be allowed. And mail received that does not conform to this policy will be either returned to the sender or placed in the inmate property bag until released from the facility or sent to criminal investigation unit for investigation. I know, all my pads are legal yellow pads too, Team Brittany. Jolie says, did you see AJ's comments regarding Kelsey's bail? He said it's like asking someone to provide a right thumbprint every day when their right thumb has been amputated. I did not see that. Where did you see that? Was that on the Bailey Bush show? I did not watch the whole entire thing. Thank you for your 10. I appreciate you. Sarah has been here for 16 months and she says, I love you with my heart. I love you with all of my heart. And Jolie says, Melanie, you're my favorite. I prefer watching someone that doesn't forget they are muted every 5 minutes. Thank you for your 5. I appreciate you. All right, everyone smash the like button. Smash the like button. And D. Sinovich says prayers and strength to Kelsey to get through this BS and to be united with her precious baby. Citizens of Massachusetts, please walk with signs, free Kelsey Fitzsimmons, and show support. Jackson was on Brother Counsel. Oh, okay. He was also on Billy Bush yesterday, right? With Chaz Waters, who's another one of Karen's civil attorneys. He's with Damon Seligman's firm. What happened to Damon Seligman? Has he been demoted? Has Chaz taken over? We don't know if this judge is going to hear her case at trial. He sounds like he wants to, but the way they shuffle judges around in Massachusetts, we just don't know. He was on Brother Counsel. Okay, I'll have to watch that. I barely have time to do my own streams, no less watch everyone else's, but if you tell me to go look for something and I have a timestamp, sometimes I can go look at it. AJ was very supportive of Kelsey on Brother Counselor. That's good. Why wouldn't he be, right? Why wouldn't he be? All right, my friends, thank you so much for coming to hang out with me today. We were here for, I don't know how many hours, but it kind of flew by, didn't it? An hour and 47 minutes. It's like a quickie. It's like a quickie. Smash the like button on your way out. Do all the things that YouTube likes. Please make sure you have all of your notifications set to all. And please make sure that you are still subscribed because YouTube is wonky and it's been like unsubscribing people. So thank you to the moderators for keeping it classy because this is always a very, I would say very difficult case to cover, but it's not the case so much as it is Massachusetts. No, Chris Galanti, I think not, he didn't resign from the case. It was Buzang that I thought resigned from the case, not Damon Seligman, because Damon Seligman is with the same firm that is Chaz Waters' firm, She and Finney, right? All right. Thanks, moderators. I love you guys. Couldn't do this without you. I'll see you guys soon. Stay cool, stay kind, stay classy. I know you can do it. I know you can. I promise you can. Stay safe out there because the interwebs are kind of toxic. So guide your actions accordingly. And KLM would like Nurse Kim and I to do a Ladies Night Live. Yes, we are due. We're overdue for that. Thank you so very much. Nothing like a good quickie, says Scarlet Begonias. She had rings on her fingers and bells on her shoes. All right, you guys, I will see you real soon. Stay safe out there. Peace.